Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with part 4 and prayerfully the last part of this R. Kelly appeal in the Eastern District of New York versus Robert Sylvester Kelly. But before we jump into that, some of you may know and others of you may not know, but Mr. Kelly has been officially assigned to a prison. And so, some of you may know and some of you may not know that the MCC in Chicago and the MDC in Brooklyn, those are holding facilities, mainly for people who are pending trial. So you guys know he was in Chicago when he was initially arrested, snatched off the streets while he was walking his dog back in July of 2019. And so he was held there until his trial was about to start in New York, and then he was moved over there to Brooklyn, and then he stayed in Brooklyn for a while. Then he was sent back to Chicago to prepare for that trial, and then I believe he stayed in Chicago. He may have gone back to Brooklyn maybe for a hearing or something, but then he was sent back to Chicago for the trial there in the Northern District of Illinois, and for his sentencing and that type of thing. And so now he's been assigned to a facility, and the facility is FCI, which I believe stands for Federal Correctional Institution, Butner, which is a medium security level 1 facility, which is in a place called Butner, North Carolina. Now, I don't know anything about this facility other than what they have on their website, but it seems like a typical medium facility in the federal correctional system. But what I can tell you about federal prisons, those of you who have been following me for a while know I know some folks, okay, that have gone to federal prison because they were a part of the drug culture here where I live, and they would basically bust a family and break down they didn't even break down the structure. They would arrest a family, a drug cartel, however you want to put it. And then the next day, one of their lieutenants or somebody who wasn't a part of the bust would pick up where they left off, and then they would operate for 2 or 3 years. Then they would get busted, and then somebody else would pick up, and it just went on and on. And if you have been rocking with me for a really long time, because your girl has had this channel for about 7 years now, then you know that the father of my 2 oldest daughters actually served quite a bit of time in federal prison. His drug family or drug cartel or whatever you want to call it was busted in 1991, and this was around the time when the the Clinton-Biden administration, passed the federal drug kingpin law, which basically stated that if you killed somebody as a part of your drug organization, then you could face the death penalty. And he was actually, if not the first, he was one of the first people to test that law. And right before his trial started, they decided that his case didn't fit it did fit the profile, but the person who actually killed the people that they were trying to give him the death penalty for was already serving like 100 years in prison, and had confessed to the murders, and that person held their ground, wouldn't accept a lighter sentence to say that he had ordered these hits. He took, that person took full responsibility, and so they had to drop that federal kingpin. But I say all that to say that he actually served, he was sentenced to like 80 years, like I think it was like 4 10-year sentences, and then 2 20-year sentences. So he had already served all those sentences, and then he had 4 life sentences. And last year, a judge overturned those 4 life sentences and commuted it to time served under the First Step Act, which was an Obama administration act, which had different provisions for people that were serving lengthy sentences to be released from prison. But what Donald Trump did was he lessened the requirements for like crack cocaine and that type of stuff, and what quantified as, serving for a life sentence and that type of thing. And so a lot of people, like thousands of people that were arrested in the 90s, are having their sentences commuted, and he was one of those people. And so what I can tell you guys is, if this appeal isn't, if this sentence isn't overturned and Mr. Kelly, is forced to serve, 20, 30 years, it will not be at this Butner, North Carolina facility. Because in the federal prison sentence, they are known for moving people like every few years. So every 4 or 5 years, a prisoner might get moved to another facility. And those facilities could be anywhere in the country. And I know with my kid's dad, he was like in Pennsylvania at like some prison up there that's supposed to be like treacherous, okay? He survived that. Then he was sent somewhere out west. And then I think at one point he was in Texas, just all over the place. And he ended up in a place in South Carolina that was hit by tornadoes during a hurricane or something. And then he was sent back to the Pennsylvania facility where he had served the first leg of his sentence. And then after that, he was sent somewhere, I think in West Virginia, and that's where he was at, either West Virginia or Kentucky. He was at a facility there when he was released last year. Now, as part of his so-called criminal organization, because he definitely was convicted under the RICO for the purposes of a RICO, which is a drug organization. And so multiple people went to jail with him. And I can tell you that these guys, when they got out, they had earned college degrees. They had earned certificates in everything. Like one of his friends, who's also a close friend of mine, he actually got some type of logistics degree in federal prison. He only served like 5 years. When he got out, he was hired by Goodwill. Then he left Goodwill to go work for Coca-Cola, and he worked for Coca-Cola for like 20 years. Great career, relocated in different areas, great career. Then another guy got his culinary arts degree, and he is like a chef for the DoubleTree hotel chain. So, nobody wants to go to prison, but if you got to go to prison, go to federal prison, because you have the ability, okay, to get a free college education, free medical care, all of that stuff. I think as far as Mr. Kelly's health issues, he is going to be okay, because one of the things is they have a medical facility at this prison here, so he should get the medical care that he requires. But even if there wasn't a medical facility there, the federal government contracts with hospitals and stuff like that, and so those guys are typically taken care of. Like, I don't know anybody of all the people that have been released that I know personally, not one person has came out and said that they had, that they were treated horribly, that they felt their life was in danger, or that they had gotten into fights or anything like that. It is basically, yes, you're locked up. Like, the worst part of it is that you're locked up and you're not free to leave, but they are given so many opportunities to succeed once they get out. Because one person, like, these guys have come out, started construction businesses, they've opened restaurants, and so basically taking advantage of the opportunity to have their sentences commuted or to have served their time, and then taking what they learned while they were in prison and coming back out and becoming productive citizens, not relying on illegal activity to survive. So I put the post that Jennifer Bonjean's law group put up. So if you guys want to write Mr. Kelly, you can use this address that is there. They say that his email is back up, and my understanding is that the email address won't change because he changed facilities. So the email address should still be intact. And then Jennifer Bonjean has stated that his email privileges are back, and he also can receive money deposited into his commissary account. I'm not sure what the final judgment was on the Eastern District of New York taking his money. Like, did they ever get that resolved? I know it was part of this appeal. I don't think they gave the money back, but was there a ruling on whether or not they could take future money? So you guys might want to look into that before sending any money to the commissary. So we are going to pick up, and I'm really just stalling time telling you guys this because somebody asked me on my other video, like, why did you talk so long? And it's basically to give people the opportunity to see that the video is up and to join the live chat that comes along with the video when it is initially airing. So we're on part 4, and hopefully the last part, as I stated, and we are picking up at section 6, which was government failed to prove defendant guilty of forced labor of Geronda Pace and Faith Rogers based on an isolated sex act that neither victim alleged was forced. So it says the government alleged that defendant committed the crimes of forced labor when he directed Geronda and Faith to perform an act of oral sex on him on January 23, 2010 and January 13, 2018, respectively. Where neither Geronda nor Faith characterized the isolated sex act as forced, no rational jury could conclude that defendant knowingly obtained or agreed to obtain any labor or services from them. These charges are yet another example of the government's transparent effort to stretch a statute far beyond its intended purpose to reach conduct that can no longer be reached by state authorities. And let me stick a pin here because somebody commented on my last video and was saying, basically they didn't like me reading the transcripts and the motions and the documents because I don't explain what it means. Okay, first of all, I don't have a legal degree. Okay, I have a college degree, but I don't have a legal degree. And so I'm reading this stuff, figuring it out, as I'm reading it. And you guys know I will go and look up a statute if I don't understand what the statute is, or I think you guys need to know what the statute is. But as I explained to that person, a lot of what I'm reading in this appeal, we've already read before. We've gone through it with the transcripts. We've gone through it with the appeals that were filed during the motion, during the trial, as the trial was going on. And we have read motions that were filed after the trial. And so basically what Jennifer Bonjean is doing is recapping documents that she's already filed at the Eastern District of New York level, and now she's filing it at the appeals level. But I think most of this is self-explanatory, and if I think I come across something that isn't self-explanatory, I do try to explain it to you guys. And then I'm also giving you the court cases that Jennifer Bonjean is using to support her arguments that she is clearly outlining in this document. Okay, so listen to when I say the court cases. So if you don't understand the point she's trying to make, and I'm not clarifying something that I think is confusing, then write down these court cases as I read them. And then all you have to do is enter the court case in Google, and it will come back with the case documents. And you can read it and see what Jennifer is talking about. But basically, she's just providing court cases that have set precedents already to support her argument. Okay, so let's go ahead. So it says a conviction of forced labor, which is Title 18, United States Code, Section 1589, requires the government to prove beyond a reasonable doubt that 1, the defendant obtained the labor or services of another person; 2, through inter alia, threats of serious harm; and 3, the defendant acted knowingly. Okay, and so now I'm going to look up inter alia and let you guys know what that means. So inter alia is Latin for among other things. So sort of like etc., etc., etc. That this is all included together. Okay, and so it says threats of serious harm, and 3, the defendant acted knowingly, United States versus Marcus, which was a case heard in the Eastern District of New York in 2007. The statute does not define labor of services, but is given its ordinary meaning, i.e., labor means the expenditure of physical or mental effort, especially when fatiguing, difficult, or compulsory, while service, and services in quotation, is defined as, quote unquote, the performance of work commanded or paid for by another. So the United States versus Marcus, which was heard in the Second Circuit in 2010, additionally, the government must establish a causal link between the labor and services provided by the person and the threat of serious harm. Section 1589 is intended to address serious trafficking or cases where traffickers threaten harm to third persons, restrain their victims without physical violence or injury, or threaten dire consequences by means other than overt violence. The harm or threat of harm, considered from the vantage point of a reasonable person in the place of the victim, must be sufficiently serious to compel that person to remain in her condition of servitude when she otherwise would have left. And we touched on this in the last video when I was talking about these sex trafficking, these fake sex trafficking busts that they have here, where they'll arrest like 200 people, be all over the news, and they're basically Johns, like people who have gone to have sex with prostitutes, but they have just like thinned the line on what is sex trafficking and what is prostitution and kind of meld it all together. But sex trafficking is way more serious because these people live in fear of their lives if they try to leave the people who are trafficking them. And so we know that Geronda and Faith didn't experience any of that. So I don't even know what they're talking about. So then it goes on and says, according to the government, on January 2010, defendant violated the forced labor statute by using threats of violence to obtain labor, an act of oral sex, from Geronda. Accepting the government's evidence in its best light, Geronda described an isolated incident in which the defendant assaulted her because he was angry that she disrespected him. Geronda testified that after the assault, she sat down with the defendant in the VIP room and he instructed her to perform oral sex on him. Geronda complied. Geronda did not testify that defendant threatened her forced her, or even demanded that she give him oral sex. Geronda did not claim that she feared defendant would assault her again if she declined the request. Geronda did not even testify that she did not want to provide the defendant with oral sex. After the incident, Geronda left defendant's home of her own free will. And if y'all recall, Geronda said she told him she had to go up the street to her uncle's house to get some shoes. And he said, okay. Now that don't sound like nobody being held against their will, right? And had he ever met this uncle that lived up the street? Was there really an uncle who lived up the street? No, there was not. So accepting Geronda's account as true, which we don't, because she is a liar, pants on fire, and even her sisters have came out and said that Geronda sat there and lied throughout this entire trial. And then her friend Kiona also said that Geronda was a liar. Now, why none of these people were on that stand testifying on Mr. Kelly's behalf? I've heard different stories, like they couldn't afford travel and the defense didn't have any money to pay for their travel, that the government threatened them with other stuff, that this might come out, or you could be charged because you knew Geronda had lied about her age and she was really underage. Yeah, I just heard a whole bunch of reasons as to why none of these people showed up who could have testified and put this mess to an end. So accepting Geronda's account as true, it simply does not establish an act of forced labor. An isolated act of oral sex does not qualify as labor or services. Where there is no commercial aspect to the incident and the victims never testified that they expected any type of benefit from the act. Moreover, the record does not show that Geronda gave oral sex to the defendant out of fear or threats of violence. Notwithstanding the prior assaultive behavior, it would not have taken much for Geronda to make the casual link between the act of oral sex and her fear of physical assault by the defendant, but she simply didn't. The jury was not free to jump to such a conclusion in the absence of Geronda's testimony, particularly where this event was an isolated one. Similarly, no rational juror could conclude, based on the evidence adduced at trial, that defendant knowingly obtained or agreed to obtain any labor or services from Faith on January 13, 2018, who testified that she traveled to Los Angeles to see defendant with whom she had been having a romantic relationship. She described an incident where she and defendant were in a small room in his studio. Faith claimed there was a gun in the room that made her intimidated, but conceded that defendant never threatened her with it or made any gestures that he intended to use it. Faith was simply uncomfortable by its presence. After an intense conversation during which Faith described defendant as being serious but not threatening, defendant directed her to give him an oral sex, I don't think N is supposed to be there. Okay. Defendant directed her to give him oral sex and grabbed her neck before placing his penis inside her mouth. Without objection, Faith provided oral sex to defendant, although she testified that she did not want to. Faith herself refuses to identify as someone who was forced to do anything. On cross-examination, Faith admitted that she was not a victim and had made a choice, and she has choice in parentheses, to be with the defendant. Question, and this is a transcript from Faith's testimony. So the question was asked of her. In one of the podcasts we spoke about this morning, the paper route. On that show, you said during the interview, I don't like the word victim because I don't feel like I'm a victim. I'm a young woman, and let's be clear. I made a choice to be involved with that person. Do I feel like everything he did was right? Hell no. but I had a choice. And that's why I walked away. I did not move in with him. I did not live with him. I did not take any money from him. There is a choice that you have to make. And then whoever was questioning her said, you said, or asked the question, you said that? And Faith replied, correct. And then the question was, you made a choice. And Faith responded, correct. And then the questioner said, and you're not a victim. And Faith replied, correct. So the forced labor statute was not enacted to remedy isolated occurrences like the one described by Faith. Indeed, it is not even clear from Faith's testimony that she communicated to defendant that she did not want to give him oral sex. She certainly did not end her relationship with defendant after this episode. The record fails to reflect a casual link between the isolated acts of oral sex and any threat of physical violence. Absent clear expression of congressional intent, courts should resist the urge to transform the forced labor statute to cover the circumstances alleged in Racketeering Act 6, which bear virtually no resemblance to those paradigmatic. Oh, Lord. Hold on, y'all. Get something bit me. Okay, paradigmatic, paradigmatic, forced labor cases and their victims. And then she says, C. Taviev, who I think is a judge who sits on the Fifth Circuit. And it says, describing prostitution, forced sweatshop work, and forced domestic services as paradigmatic forced labor cases. So then it goes on to say, Geronda and Faith each described an isolated sex act with the defendant that they now view as assaultive. The district court contends that the jury was free to see these specific instances or incidences as forced labor. In light of other evidence it heard about defendants' conduct towards other women, but the government was not free to bootstrap testimony from other alleged victims to bolster their forced labor theories as to very specific acts charged in the indictment. Geronda and Faith were not living in a condition of servitude through threats of physical force. They each described a discrete act that at best might have been charged as some type of sexual assault, and even that seems unlikely. To construe these events as acts of forced labor would render the purpose of the statute meaningless and afford the federal government free rein to charge any act accompanied by harsh or unkind words as forced labor. And when I think about forced labor, I'm thinking about I work for you and then you're forcing me to do something that's outside of my job description. Now that's, if I was sitting on the jury and somebody said forced labor, that's what I would think that they are talking about. And then you also have to consider that neither Geronda nor Faith actually lived with R. Kelly. And I cannot say enough that I am just my brain just cannot force me to believe that that man actually fooled with Geronda or had anything to do with Geronda. But, anyway. Forced labor to me just doesn't match up with what their testimony was and with what the government was trying to prove when they charged him with that. So then we move over to Section 7. Defendant was denied a fair and impartial jury where several of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify patently unqualified jurors. So it says, as United States Supreme Court Justice Blake stated in regards to Michael, which was a case that was heard in 1945, It is difficult to conceive of a more effective obstruction of the judicial process than a juror who has prejudged the case. That is because due process means a jury capable and willing to decide the case solely on the evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. And then she cites Smith versus Phillips, which was a case heard in 1982. And then in Irwin versus Dowd, D-O-W-D, which was a case heard in 1961, the United States Supreme Court observed, the right to a jury trial guarantees to the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true. Regardless of the heinousness of the crime charged, the apparent guilty of the offender, or the station in life which he occupied, a juror who has formed an opinion cannot be impartial. Okay, so if you go in that court and you done been sexually assaulted in your past and you sitting on that jury judging somebody who's charged with a sex crime, then you've already made up your mind that because this happened to you, that they are guilty of what they did, because that's what people sit on social media all day long and do. They always start their argument with, this happened to me. And then they go on to say why they believe that somebody is guilty of what they've been charged with. And it's like, what happened to you, sweetheart? Has nothing to do with this case. And so that's basically what Jennifer is saying. These people had done watched Surviving Lies. They had done read newspaper articles, all kinds of stuff, and then sat their butts up there on that jury, knowing good and well that they were prejudiced from day one. And the prosecutors purposely sought out people like that and then went in there and told them people to find that man guilty, changing the wording in the documents and all kind of craziness. So then it says, in this case, the record shows that at a minimum, 4 of the seated jurors 3, 4, 5, and 12, were not qualified to serve. And put a pin here. So you got at least four people sitting on the jury who have already made up their mind. Now, what do you think happened when they got into that got into the deliberations in the jury room? Anything that anybody might have brought up, the other 8 jurors might have brought up, any questions that they may have brought up during deliberations, those 4 people were already prepared to counter whatever that person was saying or thinking with what they call proof of why he was guilty. Oh, on the Surviving R. Kelly show, this happened, or, you know, when that happened to me, this happened. So yeah, what you talking about? No, that don't count. I'm telling you, he's guilty. And those 8 people knew after day 1 that they weren't going to get anywhere with them 4 people. And so when they came back the next day, they said, you know what, he guilty. Now, we don't believe that Sonia chick, so we'll compromise and say that Sonia, he's not guilty of Sonia because it doesn't fit the pattern of what he's been charged with. But then we can all just say, okay, he's guilty on those other charges and let's go home. And that's why the jury decided in a matter of hours that he was guilty on all counts except for those involving Sonia. So it goes on to say there were several other seated jurors who likely should have been struck for cause, but trial counsel failed to conduct any meaningful voir dire of these jurors to determine whether they could put aside their expressed biases and prejudices. Trial counsel's performance was objectively unreasonable when he failed to move to disqualify patently unqualified jurors and failed to conduct any meaningful voir dire. or prospective jurors who express their prejudgment of the case. Okay, and for those of you who don't know what voir dire, it's basically the process that's used. So if you've ever been called to jury duty, it's like a bunch of people. Okay, so first of all, they send out a questionnaire. You can either do the questionnaire, like written questionnaire, and mail it back. Some places like here, it's actually online. Like you get a card in the mail and it tells you to go to this website, and then you do the questionnaire online and submit it. And then they determine a lot of people, not like a lot of people, but a lot, as in a group of people. And they tell those people to come to court on a certain date and time. And then once they're in there, I think it's been so long since I actually did jury, made it to the process of going to the courtroom. But I think they do like another questionnaire there, and then they go through that and they dismiss people, and then they get down to the group of people that they actually want to do the voir dire. And with the voir dire, each side, the prosecution has so many what they call strikes, and then the defense has so many strikes. And what a strike is you ask a person questions, and then if you don't like their questions, you think it's prejudicial to your client or to your side, you can say, okay, I want to strike this person. But you only get like 3 or 4. In this case, they might have had like 6 strikes or something like that. I'm not sure of the exact number. But, once you use up all your strikes, then you can't stop the other person from putting somebody on the jury that you wouldn't want to be on the jury. So you have to be real careful about your strikes. So it says any meaningful voir dire or prospective jurors who express their prejudgment of the case. Defendant was prejudiced by his counsel's substandard performance, where it resulted in the seating of at least 4 seated jurors who were actually biased and could not act with impartiality. And then she cites a case that was Strickland versus Washington, which was heard in 1984, and then another case, which was United States versus Torres, which was heard in the 2nd District, in the 2nd Circuit, which was an appeals court in 1997. And this case is actually being heard in the 2nd Circuit. Or this appeal is, they're trying to get the 2nd Circuit to hear the case. So because of extraordinary pretrial publicity, the district court directed the parties to jointly prepare a juror questionnaire to probe, inter alia, among other things, prospective jurors' exposure to pretrial publicity. The court invited the parties to review the questionnaires in advance of jury selection and determine whether they could agree that certain individuals should be excluded for cause. After completing that process, the parties were left with a set of potential jurors for oral voir dire procedures. The court gave both sides the opportunity to pose additional questions to prospective jurors. Inexplicably, defendant's counsel failed to challenge several jurors who ultimately sat on defendant's jury who were plainly incapable of serving as fair and impartial jurors. Juror number 4 revealed in the questionnaire. Question 39. The charge in this case involves allegations regarding exposure to one or more STDs. Is there anything about such an allegation that you believe would affect your ability to serve as a fair and impartial juror? And the person answered, yes, I find transmission of STDs in a non-consensual act to particularly be repulsive. Okay. And then it says, and then question 79, which publicly known person do you least admire? And that person said Jeffrey Epstein. That's what Jeffrey had to do with this. And then it says, although the court generally asked the juror whether anything he or she read would affect his or her ability to be fair and impartial in the case, and the juror replied, not that I know of. Defense counsel failed to ask the court to question the juror further, to question the juror whether his feelings of repulsion about the transmission of STDs in a non-consensual scenario would interfere with his or her ability to serve as fair and impartial juror. A juror who expressly admitted that his or her feelings about the non-consensual transmission of STDs would affect his ability to fair and impartial, I think she meant to be fair and impartial, should have been struck for cause out of the gate. Inexplicably, the juror was not challenged or even questioned about his repulsion for the precise act for which defendant was charged. That this same juror named Jeffrey Epstein, an accused pedophile, as the person he least admires is yet further support that juror number 4 was not a juror who could serve with impartiality. Juror number 5 disclosed the following in his or her questionnaire. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? And the person said yes. And then the question was, what were your general impressions? And the person replied, he loves underage girls. Question 32. From what you have seen or heard, do you have a general impression of defendant? And the person replied, yes, very negative. And then the next question was, why do you feel that way? And the person said, the allegation that related, and then she says he was sleeping with underage girls, minors. Not sure what they was trying to say, but I think basically that the person would feel that way due to the allegations about him being with underage people. So although the court asked the prospective juror general questions about her ability to quote unquote put aside other things she might have heard, when asked if she could be fair, the juror indicated that she would quote unquote give it a shot. The court reminded the juror that she had to be certain that she would consider any evidence offered at trial, and the juror begrudgingly acquiesced, meaning that she gave in. So even the district court expressed concern about juror number 5's ability to serve, observing, so I don't know about you, but when someone says they think they can do something in this context, I don't think that's an unqualified assurance. And I don't know what the party's position is on that. I think I pushed her pretty hard on it, and we still ended up with, I think so. Let me hear from the government if you have a position on that. Not surprisingly, the government was confident that the juror could be fair. The court still expressed doubts. Inexplicably, trial counsel agreed with the government and the juror was seated. So where they're saying the court was questioning, that was Ann Donnelly, who was saying, hold up. Like, are you listening to her answers and you still want this person to be on the jury? You still think they can be fair and impartial? And them hookers, them AUSAs was like, oh yeah, I think she'll be fine. And then Nicole and them said, yeah, we think that person would be fine too. Child. Okay. So it says the trial counsel's performance was objectively unreasonable, where he agreed to the seating of juror number 5, who not only watched Surviving R. Kelly, but concluded that defendant loves underage girls. There can be no trial strategy for failing to excuse this juror for cause. Had trial counsel challenged this juror, the court would have undeniably struck her for cause, since the court had to bring up to y'all that this person should not be on this jury. So trial counsel not only failed to move to disqualify the juror, He did not even ask the court to probe more deeply into the jurors' statements on the questionnaire that defendant loves underage girls, or her statement that she had negative feelings about the defendant because of allegations that he engaged in sex with minors. So juror number 3 provided the following information in the questionnaire. Question 29. The case for which you are summoned involved the defendant, Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, or people involved? Answer. I watched the documentary, but I forgot the name of it. Question 30. Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? And the person replied, yes, entertainer. I heard that he has been sleeping with underage girls. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Answer, yes. Question, what were your general impressions? Answer, I saw a documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. Trial counsel did not ask the court to question the juror further about his responses to those questions or to determine whether the juror could truly serve as impartial and unbiased in light of having watched the salacious and highly prejudicial docuseries. Not a single question of the juror about his impressions of the documentary, nor did counsel ask the court to inquire about what information he learned about defendant's prior legal issues or his reputation for sleeping with these individuals. Juror number 12 offered several alarming answers in response to the questionnaire that justified disqualification. Question 29. Have you read, seen, or heard anything about the case, the alleged crimes, or people involved? Answer, yes. Question. Describe in detail what you recall reading, seeing, or hearing about, etc. Answer. Sex with minors, specific details do not come to mind. Parodies on TV regarding details of defendant's personal life. Saturday Night Live, Dave Chappelle was in jail prior, then released. Question 32. From what you have seen, read, or heard, do you have a general impression of the defendant? Answer, somewhat negative. Question, why? Answer, I really never cared one way or the other regarding the defendant. The somewhat negative impression is an emotional one impacted by the nature of the charges against him. The juror was asked about his or her ability to be fair, and the court obtained assurances from the juror that he or she could, but trial counsel did not bother to ask. Let me see. The court to inquire about the juror's reference to defendant's personal life, sex with minors, or Dave Chappelle's Saturday Night Live skit, which referenced prior allegations against defendant of videotaping a sexual encounter that depicted him urinating on someone, a crime for which he was prosecuted. It is beyond comprehension that trial counsel would not have moved to strike this juror who had seen damning pretrial publicity, knew or thought defendant had already been in jail for these offenses, and felt emotional by nature of the charges against him. The record reveals that these jurors 3, 4, 5, and 12 were not capable of deciding the case solely on the evidence before it or acting with impartiality. Beyond these 4 jurors, at least 4 other jurors likely were incapable of acting as indifferent. Well, child, that's what, 1/3 of the jury so far? So it says, an impartial triers of the fact However, let me read that again because I talked in the middle of it. Before these 4 jurors, at least 4 other jurors likely were incapable of acting as indifferent, I think she meant fair, and impartial triers of the fact. However, defense counsel did virtually nothing to probe the attitudes of these prospective jurors. So it's 12 people on the juror, and you saying at least 8 of them were not going to be fair in their judging of the case. Like, child, that is a big problem. Let's see. Have I lost my page here? Hold on a second. Okay, so jurors number... Hold on, I got a cough. Ooh, sorry about that. Jurors number 7, 8, 9, and 11 all revealed that they had heard about the case and the alleged crimes and expressed knowledge about defendants' prior issues with the law. Without exception, trial counsel failed to probe what precisely the prospective jurors had heard or conduct a meaningful inquiry into whether they could be fair given what they had heard or seen. An attorney cannot make an intelligent decision about whether to challenge a potential juror for cause or whether to exercise the defendant's preemptory challenges without properly questioning jurors to learn or potential biases. Questioning potential jurors to learn of potential biases. And then she says, see Connors versus United States, which was a case that was heard in 1895, holding that an adequate voir dire is essential to ensure that prospective jurors will be free of bias or prejudice and will perform their duties impartially. And then Rosales-Lopez versus United States, which was a case heard in 1981, holding that voir dire plays a critical function in assuring the criminal defendant that his Sixth Amendment right to an impartial jury will be honored. United States versus Blount, which was heard in the Sixth Circuit in 1973, holding the primary purpose of the voir dire is to make possible the impaneling of an impartial jury through questions that permit the intelligent exercise of challenges by counsel. So, when I'm reading these cases, she's using rulings by appellate judges and by the Supreme Court judges that support her argument. Okay, and so when I read that part after, like I said, Rosales-Lopez versus the United States, and then I told you the year that the case was heard, then I read that part about holding that the voir dire plays a critical function. That's an excerpt from the ruling from whatever court was hearing this appeal. So I'll read the case number, tell you what court it was in, what year it was, and then what I read after that is what one of the judges or an agreement of all the panel came to that conclusion, and that's what they decided on that particular aspect of the appeal. So moving on, under the standard promulgated by Strickland Supra, trial counsel failed to provide effective assistance of counsel to defendant when he failed to move to strike unqualified jurors 3, 4, 5, and 12, and overall failed to conduct a reasonable voir dire to probe the stated biases of several other seated jurors. To prove a successful claim for ineffective assistance of counsel, defendant must demonstrate that 1, counsel's representation fell below an objective standard of reasonableness, and 2, There is a reasonable probability that, but for counsel's unprofessional errors, the result of proceeding would have been different. And then Strickland, and so Strickland, I can't remember which case I cited. Strickland is a judge, okay, who's hearing an appeal. And so it says, in this context, the prejudice prong of Strickland is satisfied. Nope, I got that wrong. Let me go back up here. Was Strickland a case that I talked about? Because I don't want to give y'all no misinformation. Strickland. I really think that Strickland was a judge who was hearing an appeal. Let me go back down here and see if this is her. Defendant, then he failed to move to prove a successful claim. Objective standard of reasonableness. Okay, she says, in this context, the prejudice prong of Strickland is satisfied. So I think Strickland was the judge that was hearing the case. Okay. So let's go. So she says, in this context, the prejudice prong of Strickland is satisfied by a showing that the juror was actually biased. And then Torres, she says, defining actual bias as bias in fact. And Torres, I think, is another appellate judge. Or the existence of a state of mind that leads to an inference that the person will not act with entire impartiality. Let's see. Okay, guys. My voice is starting to go, but I am going to try and push through this because I want to finish this. I don't want to have to come back and do another video, so bear with me. So defendant has satisfied both prongs of the Strickland analysis as set out above. Juror 3, 4, 5, and 12 express views that lead to the inference, indeed the certainty, that they would not and could not act with entire impartiality. Trial counsel's failure to move to disqualify them was substandard. Apart from their own words that two of those seated jurors had seen surviving lives is evidence of bias in fact, where no human being could act as a fair and impartial juror after seeing a docu-series that painted defendant as a serial predator. The docu-series was 11 episodes and consisted mostly of interviews from alleged victims who graphically detailed their claims of sexual abuse. Some of the information communicated in the docu-series was presented at defendant's trial, but much of it was not, meaning that at least two jurors had highly prejudicial information untested by the adversarial process to consider in addition to what was presented at trial. The docu-series highlighted the stories of scores of women who claimed to have been victims of sexual abuse and offered no countervailing viewpoint. Okay, let me stick a pin here and go back up here. So what she's saying is basically what I said earlier, is that they were in that jury room, right, going over this so-called evidence. And those people that had saw that docu-series or a docudrama, because we cannot call it a documentary because there was nothing factual, researched, or proven. It was just a platform for people to get on the microphone and just say whatever they wanted to say without proving that any of it actually existed or happened. So you have people on the jury who sat through that, who are now in the decision phase, sitting in the jury room. And then if somebody says, well, child, I can't believe that happened, or I don't think that, that rose to the level of the charge. And then you got these people that have watched that show sitting there saying, I saw it, and child, this is what happened. So this is what Tiffany Hawkins said, or this is what Javante Cunningham. Remember, she was the one that was the bad ex witness who claimed that she saw him and Aaliyah on that van. Well, this is what she said on the documentary. And they're repeating to everybody else on the jury what happened on the documentary, even though some of the people whose testimony that you're supposed to be judging were not part of the documentary. Some of them were the bad act witnesses who, if you think about it, bad act witnesses in a federal case. Why are you not one of the alleged victims? Why isn't your trauma of what you experienced part of this trial, being tried on this trial? And anybody with common sense would say, obviously they can't prove what this person is saying is true or actually happened, or it didn't occur the way they say it happened, or they were older than what they was, blah, blah, blah. Because we literally had Javante Cunningham get up there as a bad act witness and say that when she was 13, 14, that her and Tiffany Hawkins and all these other girls used to go to this man's apartment, and there was a police officer who I think testified. That guy, I think he was one of the people that testified for Mr. Kelly, but he allegedly was in the hotel along with Demetrius Smith, who testified. He was not the hotel, but the apartment was in the apartment. So several guys, Keith was in the apartment. All these people was in the apartment when these young girls were going into the apartment and then going into the room and doing whatever they was doing in the room, I guess having orgies or whatever. Yet none of these people were charged as part of the RICO, as part of the enterprise. Did these jurors not put two and two together to say, hey, this doesn't make sense, that if this happened to you when you were like 13 or 14 years old, why are you a bad act witness and not one of the victims that he is being tried for? Like, nobody in that jury sat there and thought to themselves, now this doesn't make sense that all these people sitting here telling us all these wild tales and all these stories, but they're not victims in the case. They're just witnesses here telling us these stories. Why is that? Nobody asked that question. But anyway, so what Jennifer is saying is that they had people in the jury room that could go back and reference parts of Surviving Lies to convince the other jurors why he is guilty. So let me see, where was I? Let's see, the docuseries highlighted the stories of scores of women who claimed to have been victims of abuse and offered no countervailing viewpoint. A large part, and then she has some notes at the bottom before I finish that sentence. She cites RollingStone.com, TV features, Surviving Lies Lifetime docuseries. And then in this Rule 33 motion, defendant referred the district court to Surviving Lies series, which can be streamed on several platforms, including Netflix and Amazon Prime. Defendant also embedded the following links to his reply, which are excerpts from Surviving Lies that any juror who had seen the documentary would have seen prior to serving on his jury. And then they have some videos that they took from YouTube. I wonder what these videos are. I think they're advertisements. I'm not going to click on that. I think they're advertisements for Surviving Lies that were on YouTube. Let's see. So a large part of the documentary detailed defendant's prior criminal case that involved allegations of abuse of a 14-year-old, which included allegations that he videotaped himself urinating on her, and which was the subject of the Northern District of Illinois prosecution. It is nothing short of mind-blowing that defense counsel acquiesced to the sitting of jurors who came to the case with this highly prejudicial information that no human being could have put aside. For this part, or for his part, defendant explains that he was effectively absent throughout the voir dire process, even though jury selection is a critical stage of trial at which defendant had every right to participate. Okay, it says defendant had the constitutional right to be present and participate throughout his voir dire process. His declaration demonstrates that he was a spectator as his attorneys picked the jury without his input, including individuals that should have been struck for cause. Because defendant's jury was comprised of several jurors who could not discharge their constitutional duty to be fair and impartial, defendant did not have a chance at defending against the allegations. Defendant was denied his constitutional guarantee of a fair and impartial jury and his Sixth Amendment guarantee of effective assistance of counsel when his attorney failed to move to strike jurors 3, 4, 5, and 12, or otherwise conduct any meaningful voir dire of the remaining jurors. So, number 8. Defendant was denied a fair trial where the government swamped the jury with excessive other bad act evidence, including testimony from several. Y'all, I don't know if I'm going to make it to the end here, but I'm going to keep trying, so bear with me. Including testimony from 7 additional witnesses who detailed defendant's unusual and graphic sexual activities, his history of transmitting herpes to his sex partners, his abusive conduct towards his girlfriends, and even audio and video recordings of this conduct with women and men, some of whom never testified. With virtually no limitation, the district court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under the theory that the evidence was relevant to the means and methods of the enterprise. Now, child, who had them forgot about the enterprise? Because we talked about the enterprise, I think, in the first part, but we didn't really mention the enterprise in this part here. So she's reminding us that this was a RICO case, that there was supposed to have been an enterprise that we don't know nothing about yet. So let me repeat that. Mostly under the theory that the evidence was relevant to the means and method of the enterprise. So the means and method justification for the introduction of copious amounts of bad act evidence is gravely flawed because the government's theory of an enterprise is flawed, where the enterprise consisted of nothing more than the purported sexual misbehavior of the defendant, unconnected to the activities of a discrete enterprise. The means and methods of an enterprise cannot justify the admission of copious amounts of bad act evidence. So, as argued before, the government or prior, the government failed to prove a RICO enterprise, no matter how much repellent evidence of sexual indiscretions or abusive behavior the government accumulated against the defendant. The fact remains that it was the defendant alone, who engaged in those affairs wholly disconnected to the affairs of a distinct enterprise. Unwitting assistance of underlings who carried bags, picked up defendants' prescriptions, and drove defendants' female guests from location to another is not proof of an enterprise. By characterizing defendants' purported decades-long history of abusive conduct toward women as an enterprise, the government not only avoided statutes of limitations, but was free to introduce any unkind or abusive act of a sexual or non-sexual nature as evidence of the enterprise, conveniently avoiding the rule against the admission of propensity evidence. Okay, so let's look up propensity evidence. Okay, character evidence is generally not admissible to show propensity. That is, for the purpose of showing that the person likely acted in a way that is consistent with the character trait of a particular occasion. And let's see, what does propensity mean in evidence? Propensity evidence is evidence of one crime that is used to show the defendant is more likely to have committed another crime. For example, the prosecution could use evidence of another act of domestic violence to help prove that the defendant committed the current crime of domestic violence. Okay, so that's propensity evidence. Okay, so notwithstanding, the district court, I think she meant, is still obligated to conduct a meaningful Rule 403 analysis, which it failed to do. Rule 403 authorizes the exclusion of relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The United States Supreme Court held in Old Chief that unfair prejudice is to criminal defendant is okay, let me go back. The United States Supreme Court held in Old Chief that unfair prejudice as to a criminal defendant speaks to the capacity of some conceitedly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offenses charged. Old Chief versus the United States, which was a case heard in 1997. The committee notes to Rule 403 explain unfair prejudice within its context means an undue tendency to suggest decision on an improper basis, commonly, though not necessarily, an emotional one. Advisory committee notes, let's see, Federal Rules of Evidence 403, as Old Chief observed. And then it says, courts that follow the common law tradition almost unanimously have come to disallow resort by the prosecution to any kind of evidence of a defendant's evil character to establish a probability of his guilt. Not that the law invests the defendant with a presumption of good character, but it simply closes the whole matter of character, disposition, and reputation on the prosecution's case in chief. The state may not show defendant's prior trouble with the law, specific criminal acts, or ill name among his neighbors, even though such facts might logically be persuasive that he is by propensity a probable perpetrator of the crime. The inquiry is not rejected because character is irrelevant. On the contrary, it is said to weigh too much crime with the jury and to so over-persuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge. The overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that its disallowance tends to prevent confusion of issues, unfair surprise, and undue prejudice. Mickelson versus United States, which was a case heard in 1948. Probative value is also informed by the availability of alternative means to present similar evidence. Specifically, the Supreme Court has advised that the Rule 403 probative value of an item of evidence may be calculated by evidentiary alternatives. And then they cite this Old Chief ruling again. It says that the district court is afforded wide discretion to exclude evidence that is, on balance, unduly prejudicial. And then Tavares, let's see, in a ruling in the Eastern District of New York in 2006, so long as the district court has conscientiously balanced the proffered evidence's probative value with the risk of prejudice, its conclusion will be disturbed only if it is arbitrary or irrational. And I think it is safe to say that those people they had up there testifying against this man, it was irrational. I think it was irrational. It didn't even make no sense. It had nothing to do with nothing. Let me see. So as set out below, this court did not conscientiously balance the probative value of certain proffered government evidence that carried an extraordinary risk of prejudice. So A, excessive STD evidence. The government charged the defendant with committing several racketeering acts based on his transportation of Ariel and Faith to California and New York with an intent to expose them to herpes in violation of local public health laws. The district court repeatedly noted that under its interpretation of the statutes, the government was not required to show that defendant transmitted herpes to Ariel and Faith. Mere exposure was sufficient. Even if the district court was correct, there was little justification for allowing massive amounts of evidence that defendant purportedly spent decades receiving and transmitting sexually transmitted diseases, Lord have mercy, through defendant's personal physician, Dr. McGrath. The government presented evidence of defendant's entire medical history concerning the contraction of STDs dating back to the 1990s, including his prior diagnosis with such STDs as gonorrhea and chlamydia. Oh, child. Let's see. Dr. McGrath further testified at length about his treatment of defendant for herpes. In addition, Dr. McGrath's testimony, the prosecution elicited testimony from every person who testified about sexual contact with defendant about whether defendant disclosed his herpes diagnosis with them. The prosecution also presented testimony from 3 additional witnesses, Geronda, Kate, and Anna. Can't remember who Kate might have been her real name. Anna, we know, was Holly Calhoun. That defendant infected the women with herpes, eliciting descriptions of herpes infection symptoms. And if that was not enough, the prosecution offered extensive documentary evidence regarding defendant's herpes treatments and elicited graphic details from multiple witnesses about the symptoms of herpes. The prosecutors uttered the word herpes hundreds of times throughout his trial. There was no legitimate basis to bombard the jury with excessive evidence about defendant's herpes diagnosis or the fact that he had allegedly transmitted the disease to a number of different women. The only issue in dispute related to defendant's herpes diagnosis was one, whether he had herpes in 2015 and 2018 when he had sexual relations with Ariel and Faith. 2, whether he knew he had herpes, and 3, whether he disclosed it to the women before they had intercourse. Well, I don't think he ever had sex with Faith, did he? Did they ever go all the way? I can't remember. If they did, it was only like one time. So Dr. McGrath testified unequivocally that as of 2015, defendant was diagnosed with herpes and was being treated for herpes. Both women testified that they had unprotected sex. Wait a second. They had unprotected sex with defendant, and that defendant did not disclose that he suffered from herpes. This evidence went unrefuted. Accordingly, an additional evidence related to defendant's herpes diagnosis and transmission of herpes to other women was unnecessary, cumulative, and unduly prejudicial. B. Evidence concerning sexual relations with Aaliyah. The prosecution charged defendant with one racketeering act of bribery for the sole purpose of getting evidence before the jury about his marriage and relationship with Aaliyah. Over defense counsel's objection, this court permitted the prosecution to introduce testimony from Angela, who is Jane Doe number 7, and you guys know Angela is Javante Cunningham, that she allegedly observed sexual interactions between defendant and Aaliyah in 1992 on defendant's tour bus. This court erred by allowing this highly prejudicial testimony into evidence after initially denying the government's request. Angela's testimony was not relevant under the means and methods theory since it purportedly occurred pre-enterprise, which the district court concedes in its order. And then she says, instead, the district court defended the ruling on the grounds that the evidence was necessary to show defendant's motive for bribery, particularly since defendant would not confess to having sex with Aaliyah. Whether the defendant had a motive for committing bribery did not justify putting this inflammatory evidence before the jury. Now, child, in 1992, wouldn't Aaliyah have been like 12 years old? Where were her parents? Because her mama said that her child never traveled with R. Kelly without her. And then put a pin here. Somebody, I think I was on, it might have been in the comments of the last video. I can't remember who the person was. So please forgive me for not giving you a shout out. For giving me this information, and I don't want to say the wrong name even though there's a name in my mind, but they were saying that Aaliyah's mom is supposed to be coming out with a documentary of some sort where she's supposed to expose the truth, I guess. Now I don't know about the truth about this situation or whether it's just about Aaliyah's career or what the documentary is supposed to be about, but I will be looking out for that, and as long as it's not on Lifetime, I'll be watching. But if it's on Lifetime, y'all gonna have to fill me in on the details, because I literally have not watched Lifetime television since 30 minutes into episode 1 of Surviving Lies. Okay, that was the last time I turned to channel 253, I think it is, on DirecTV. So moving right along. Oh, I take that back. I did watch the Wendy Williams documentary because I love me some Wendy Williams. And I know that Wendy Williams herself directed her documentary. Like, she was the one that put it out there. So I did watch the Wendy Williams documentary. But aside from that, I have never watched Lifetime since the first 30 minutes of episode 1 of Surviving Lies. Okay? That's the only exception. So it goes on, it says, instead, the district court defended the ruling on the grounds that the evidence was necessary to show defendant's motive for bribery, particularly since defendant would not confess to having sex with Aaliyah. Whether the defendant had a motive for committing bribery did not justify putting this inflammatory evidence before the jury. And it wasn't even evidence, y'all. It was just some hearsay, because she seemed to be the only one that has ever seen this. So even if the government, oh, that's right, it's not hearsay because she's giving direct knowledge of what she saw. So it was just a bold-faced lie, okay? Because we know that didn't happen. So even if the government believed that it needed to present some evidence of motive, it did through the testimony of Demetrius Smith, who assisted, who assisted in obtaining a false identification card for Aaliyah so she could marry the defendant, testified that in 1994, the defendant told him that Aaliyah was quote-unquote in trouble and quote-unquote thought she was pregnant. Smith further testified that the decision to marry was Aaliyah. Okay, I don't think that was. Okay, the decision to marry, let's leave that, was Aaliyah, and then put in was, made so that defendant could avoid legal issues. The government had plenty of motive evidence to present and had no need for the wildly prejudicial testimony of Angela that was not corroborated by any way or anyone, I think is what she meant. As such, it was error to allow Angela Javante Cunningham to testify about her alleged observations on the tour bus in 1992. And why would Aaliyah even been traveling with him in 1992? Because I thought he had just met her in 1992. Wasn't it 1992 that they testified that Barry Hankerson brought him to Aaliyah's house to meet the family? So why would they then allow her to travel unaccompanied? Okay, Shy. Anyway, I can't even be trying to stretch my brain to try to see things the way that this prosecution put this case on. So see, testimony from Addie, Alexis, Kate, Holly, Angela, Lewis, and Alex. Child. And y'all know Lewis is actually, I can't remember his name. Why can't I remember? Richard Arline, who was a groupie, okay? Who tried to bribe Azriel not to testify. And then they awarded Azriel the same amount of the original alleged bribe. Child, it's just a mess. So this court permitted the government to present a whopping 7 additional witnesses to testify about graphic, uncharged bad act evidence concerning dozens of sexual encounters with the defendant. In its order, the district court set out a detailed accounting of the testimony of Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex. Okay, so we know that Anna is Hallie Calhoun, Angela is Javante Cunningham, Lewis is Richard Arline, and then Alex might be Alex. Okay, so apart from Javante's testimony, which concerned sexual conduct pre-enterprise, the prosecution defended the introduction of this evidence under the catch-all means and methods of the enterprise theory. As argued above, where the defendant and the defendant alone was the enterprise, the means and methods justification for the introduction of copious amounts of bad act evidence is simply a free pass at introducing unlimited bad act evidence related to defendants. Hold on a second. I'm trying to get back to my place, y'all. This thing is jumping around. Okay, related to defendants. Let me click on the next page so it don't skip back up. And it did it anyway. I'm sorry. Okay, related to defendants' alleged misdeeds and abusive conduct, the circular logic returns us to the overarching defect in this prosecution, namely that it was a prosecution of defendants' bad character and unpunished sexual misdeeds. It had nothing to do with punishing or preventing the conduct of an enterprise. The district court suggests that Addie's testimony about her sexual acts with the defendant was probative of the enterprise, but fails to explain how or why. Addie testified that when she was 17 years, she went... Okay, I think she meant she went to one of defendant's concerts. Defendant announced from the stage that only women over 18 could go backstage, and she did not go backstage because she had no identification. According to Addie, two bouncers, in quotations, asked her if they wanted to get defendant's autograph, but did not ask their age before bringing them backstage to defendant's dressing room. According to Addie, defendant provided her autograph and engaged her and her friend in sexual activity. Indeed, the way Addie tells it, defendant forcefully assaulted her in the dressing room. No one was present for the sexual activity other than the defendant and her friend. The testimony added nothing to the government's theory of an enterprise, particularly where it is unclear that the mysterious bouncers even worked for the defendant, and Addie admitted that they would have had no idea she was 17, or rather than 18. Indeed, all of the other bad act testimony that came from Alexis, I can't remember who was Alexis, Javante, Richard, and Alex, was designed to put before the jury evidence of defendant's propensity to engage in prohibited sexual activity with minors. Okay, it shed no light on the existence of an enterprise. While there was some vague testimony that nameless... What happened? Okay. Hold on, guys. I done lost my... I don't know why this thing keeps jumping around. Pass along defendant's phone number. Minus... Let's see. Though these bad acts. Okay. It shed no light on the existence of an enterprise. While there was some vague testimony that nameless bouncers or associates invited young women backstage or passed along defendant's phone number, there was no testimony that these nameless individuals had any knowledge that these young people were minors rather than 18 years old. If an enterprise is formed simply because members of a rock star or rapper's entourage invite teenagers backstage to meet an artist, the government should be overloaded with RICO prosecutions against recording artists. That a bouncer allows a 17-year-old backstage after an R&B concert is not evidence he or she is recruiting minors for the defendant. Illegal sexual conduct. Through these other bad acts witnesses, the jury was inundated with one jarring story after the next of unconventional graphic sex acts, including sexual conduct that many, perhaps most, would consider deviant. Example, group sex, elements of BDSM, and coprophilia. The government presented detailed testimony about defendants' sexual activities with men, group sex, and even elicited testimony from Anna or Hallie about defendants' penchant for sex involving coprophilia, which she described and demeaning, and I think she meant described as demeaning and humiliating. Okay, then there's some notes at the bottom. It says Merriam-Webster definition of BDSM, sexual activity involving such practices as the use of physical restraint, the granting or relinquishing of control, and the infliction of pain. And then Merriam-Webster definition of coprophilia, marked interest in excrement, the use of feces or filth for sexual excitement. Now, if the defense was smart, what they would have done was ask the jurors about what was that movie, 50 Shades of Grey, part 1, 2, and I think there was a 3. Like, have you watched that? Do you understand that there are people in the world that enjoys this type of behavior? Like, would you judge someone negatively if they were into the things that you saw taking place on 50 Shades of Grey, and then named some of these sex acts that were featured in these movies? That should have been part of the questionnaire, and that should have been part of the voir dire, okay? To find out what were these people's thoughts on this type of behavior, because believe it or not, there are people that are into this. And I was sharing with someone on Twitter about this lady who had made this post on Facebook several years ago where she was warning young women. So evidently, and we have seen Halle do this. We've seen the girl who was the fashion coordinator for Mr. Kelly. What do they call those people that groom them, tell them what to wear, find them clothes and stuff like that? Oh, I can't think of that girl. Cash. I think her name was Cash. Not Cash Jones, but another Cash. And they have gone to Turkey and Dubai. We know Ariel is constantly going to Dubai. We know the allegations that were made to her by this guy that's from Dubai. And so what this lady was saying on Facebook a few years ago is that basically she needed some money. And so somebody had hooked her up with these guys in Dubai, and they were going to pay her $40,000 to come over there, right? So they sent her airfare, sent her travel money. She goes over there. She ends up in a room with multiple men. So it was like 3 or 4 men, right? And they basically can do whatever they want to do to her. Well, when it got to the coprophilia part of it, she wasn't feeling it, right? And so she said that they, was like disappointed in her. So they left the room. Then one of the guys came back and was like, hey, if you want this money, you got to, it's whatever we want. So she was like, okay. So she said they had put plastic down on the floor or on the bed or something, and no plastic was involved. And then they came in and they urinated and crapped on her, like they had to took enemas or something, crapped all over her. And then she was supposed to like get on her knees and smear it all over her body and stuff like that. So she went along with it, was like, well, damn, I can take 100 baths afterwards to get this off of me. But honey, you can never cleanse your mind from these experiences. So child, anyway, she did all this, went and got cleaned up. They cleaned up the room and everything. And homegirl said she came back, the man gave her $5,000, not the $40,000 that she had done went over there for. And when she asked them, well, where's the rest of my money? They said, no, you wasn't into it. Like, we needed you to be into it and find pleasure in it, or even pretend that you found pleasure in it. But we could tell that you were repulsed by it. So here's your $5,000 and your plane ticket back home. Now get to stepping. So when you be hearing about these folks who ain't got no jobs, who ain't going with their family and friends, but they always hopping on a plane, going to Dubai, going to Turkey and all these other countries, and then they coming back with money, but they ain't got no job, living their life, but they ain't got no job. That's what they doing. They going over there making $40,000, $50,000 to let men do despicable things to them. So anyway, we're going to move on. So it says, when considering this mass of prior bad act evidence cumulatively, its probative value is diminished exponentially as compared to its prejudicial effect. There can be little doubt that defendant's jury was inclined to rectify past injustices by punishing defendant, even if it harbored doubt about his guilt on the charged offenses. The risk of prejudice and confusion was particularly acute where the trial devolved into a live rendition of Surviving Lies docuseries replete with viewings of sexually explicit videos. So D, admission of graphic videos and audio recordings. If days upon days of testimony of other bad act witnesses was not enough, the government was further permitted to introduce private videos of graphic sex acts, some of which have BDSM elements. Government exhibits, let me be clear and give y'all a definition of BDSM before I am accused of just reading these documents and not explaining what this stuff means so that people can follow along. Okay. So BDSM is a variety of often erotic practices or role playing involving B, bondage, D, discipline, D, dominance, and S, submission, sadomasochism, I think that's how they pronounce it, and other related acts. Okay. And if you need further references, go and rent 50 Shades of Grey and the follow-up movies, and you will get an example of everything involved in BDSM behavior. Okay. All right. So D, admission of graphic videos and audio recordings. If days upon days of testimony of other bad act witnesses was not enough, the government was further permitted to introduce private videos. I read that already. Okay, so government exhibits 341 through 343 were group sex acts between Alex, Dominique, and the defendant, which reflected nothing but group sex involving 2 men and 1 woman. Now, you guys remember Dominique lived with R. Kelly for like 10 years, and then after Surviving R. Kelly aired, she went home. She might have been home before it aired, but Dominique said that she was with him because she wanted to be with him, because she didn't want to work, and he was providing her with the lifestyle that she dreamed of that did not require her to work. Dominique's mother knew where she was all along and was living off of the money that Mr. Kelly was giving Dominique. And Dominique and Geronda Pace were friends. I think they met on MySpace. Geronda Pace sued Mr. Kelly several times, and she would share her money with Dominique and Dominique's mother, buying them expensive gifts. But like I said, Dominique said once she was exposed after her Surviving R. Kelly, that she would never testify against him. And then she went on, I think, part 2 of Surviving R. Kelly, but then she came back and did a video with a YouTuber by the name of Dr. Rice, where she said that she sat for hours being interviewed, and that what they did was they took those hours of testimony or hours of her interview, and then they pieced it together to give a narrative that was the opposite of what she said. So she went on the show thinking that she was going to give another side of what it was like to be with Mr. Kelly, but instead they chopped and skewed her interviews to make it seem as though he had harmed her, that she was upset. She said that when she broke down crying, she was crying because she couldn't believe that they was doing this to this man. But when the people at Surviving R. Kelly got through with her interview, it made it seem like she was crying because she was having memories of this horrible treatment, blah, blah, blah. Okay, so that's who Dominique is. Dominique is married, might be divorced by now, but she has a daughter from an older white man, so she's definitely into older men. And what I liked about Dominique was that when she got out, she got a job working at the movie theater, like the Cineplex or something. There's Cineplex here. I don't know what they are in Chicago. But she was actually working in the movie theater. Like, she did a video one day where she was cleaning up the movie theater. And this was after she had left Mr. Kelly. Then she tried to do a t-shirt business. And I actually bought a t-shirt from Dominique. I don't know why I liked her. I thought she was sincere, about everything that she had to say. And, she didn't feel the need to lie about her experience or make it more or less than what it was. It's simply what it was. So I did buy one of her t-shirts to support her. And then Dominique just rolled off into the sunset, child. We don't know. I don't know where Dominique is or what Dominique is doing, if she's still married, if she done had another baby, or what's going on with her. But if y'all know, let me know in the comments. So moving on. So Dominique and the defendant, which reflected nothing but group sex, blah, 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 involving 2 men and 1 woman who did not even testify. The district court barely defends the introduction of the videos for legitimate non-propensity purpose. Okay. Let's see. Okay, y'all, this thing keeps... Okay, so Government Exhibit 328A is a lengthy video of defendants spanking Holly, who was naked and crying, walking back and forth, calling herself a slut and stupid while defendant looked on. Once again, watch 50 Shades of Grey to get a visual of what's going on. So this video was offered for no other purpose than to show defendants sexual perversion and mistreatment of Holly. It shed no light on whether an enterprise existed and had no bearing on charged offenses. Now, it is important to note that somebody, after his case, somebody sent him a letter apologizing for testifying, saying that they were forced to do it by the government. And that was the only reason. They never wanted to hurt him. And there were 5 X's, like Xing out the person's name. So I'm thinking, let's see, Azriel. Is that Azriel? That's 6. I think it was Hallie, okay, who wrote that letter apologizing to him. Saying that she did not want to testify against him, but they forced her. And by forcing her, they probably was trying to charge her with the Mann Act or being a co-conspirator or something like that. So then it goes on to say, lastly and most problematic, the government admitted a video of Holly spreading feces on her naked body and calling the defendant daddy, although the defendant was not depicted in the video. This video, like the others, added nothing to the equation as it relates to proving an enterprise and did nothing but breed contempt and prejudice for the defendant. Defendant was entitled to a fair trial on the charged offenses. Instead, with the district court's blessing, the prosecution put him on trial for a lifetime of bad behavior. With a jury already biased against him, and the admission of a mountain of uncharged bad conduct, defendant was denied his guarantee of a fair trial. Let's see, 9. The district court's restitution award for Azriel and Stephanie's herpes treatment was unsupported by the government's evidence. After a hearing conducted on September 28, 2022, the district court ruled that Azriel was entitled to restitution pursuant to Title 18 United States Code, Section 2429, for the cost of herpes treatment, namely the cost of Valtrex, for the rest of her life. And you guys, I've already read this in the beginning. Go back to part 1 because I'm not getting ready to read this again. About the drugs and all that. Because we are approaching 2 hours. And then Stephanie, they wanted to give her Valtrex. And basically what she's saying is that there is no proof that either one of these women are taking any money for herpes. And they definitely are not taking the name brand Valtrex. So they don't need all this money. Then she talks about Azriel, where she says, let's see. The district court abused its discretion in granting Azriel nearly $300,000. And like I said, because there was no proof that she was taking Valtrex and that she could receive the same treatment with the generic brand, which is called Valacyclovir. Let's see. And remember, I told y'all when Richard Arline first came up with this bribery scheme that Mr. Kelly did not tell him to come up with. He was trying to give Azriel $300,000 not to testify, and I think that Azriel went to the government. The government told her to go back and ask for $500,000. Anyway, I think this $300,000 was her payment for participating in that scheme with Richard Arline. And y'all know Richard Arline was arrested and charged, and in exchange for his testimony, he received time served for his sentence, but the boy hadn't spent a day in jail, so I don't know how it was time served. But anyway, child. So they talk about that and how, child, it's not mandatory to give people the name brand. It says that since Azriel's contraction of herpes cannot be casually linked to any Mann Act violation, why is she getting $300,000? So the defendant was charged with a Mann Act violation stemming from a trip that defendant and Azriel took to California between April 28, 2015 and May 1st, 2015, and further charged with Mann Act violations related to the trip that took the duo to California in September or October of 2015. Let's see. Because Azriel did not and cannot connect her contraction of herpes with either of those trips, she is not a victim for the purpose of Title 18 United States Code Section 2429. Under the statute, victim is defined as the individual harmed as a result of the crime. Okay. Let's see. Like I said, as a result of the crime under the Chapter 117, namely crimes prohibited by Title 18 United States Code 2421A, Title 18 United States Code 2422A and B, and Title 18 United States Code 2423A, which are all Mann Act violations. By its own terms, mandatory restitution is required under Title 18 United States Code 2429 only when the harm suffered by the individual is shown to be as a result of the specific Mann Act offense. United States versus Goodrich, which was a case heard in 2021. The government ignores that Azriel and the defendant commenced a relationship in April 2015. Azriel moved into defendant's home shortly thereafter, where they engaged in a consensual and legal relationship in the state of Illinois for 5 years. But for 2 isolated trips to California, defendant would never have been convicted of a Mann Act violation related to Azriel. The government simply cannot show that Azriel's affliction with herpes had any connection to those specific trips. The analysis is the same pursuant to Title 18 United States Code Section 3663, where there is no nexus between the offenses for which defendant was convicted and Azriel's contraction of herpes. The Mandatory Victims Restitution Act, MVRA, defines victim as a person directly and proximately harmed as a result of an offense for which restitution may be ordered. United States versus Goodrich, just heard in 2021. Thus, in determining to whom a defendant owes restitution, the statute requires the court, 1, to identify the offense of conviction, and 2, to ascertain whether the putative victim was directly and proximately harmed by the defendant's commission of that offense. The Second Circuit explained in United States versus Valor, which was heard in the Second Circuit in 2013, restitution may be imposed only for losses arising from the specific conduct that is the basis of the offense of conviction. The government has not and cannot demonstrate that Azriel's contraction of herpes arose from the specific conduct alleged in the charged Mann Act violations or the forced labor count related to Azriel. Separately, the Circuit Court, Second Circuit, has held repeatedly that the MVRA requirements that the offense of conviction directly and proximately harmed the victim entitled to restitution. Goodrich at page 229. Courts have interpreted this language to impose cause and fact and proximate cause requirements, respectively. Again, the harm suffered by Azriel, namely her contraction of herpes, must be directly and proximately caused by the specific Mann Act violations and or forced labor offense. It is not sufficient to state that defendant and Azriel were in an abusive relationship in which he transmitted herpes to her at some point. Azriel and defendant were in a relationship for over 4 years. Regardless of how abusive Azriel now claims the relationship was, she is not entitled to $250,000 for herpes treatment, medication where she cannot directly or approximately link her herpes diagnosis to the specific offenses for which the defendant was convicted. Assuming, arguendo, the government demonstrated a sufficient causal connection between Azriel's herpes diagnosis and the charged offense, the government dramatically inflates the cost of Valtrex, even for an uninsured individual. United States versus Maynard on Second Circuit 2014, the government bears the burden of proving actual losses, not losses that are hypothetical or speculative. All right. So then she goes, once again, you can go back to part 1 for all of this here, where they're basically talking about the calculations between the generic brand and the name brand, and then they talk about Stephanie and basically say the same thing about Stephanie and the amount of money that was given to her, that they were seeking restitution on behalf of Stephanie for treatment dating back to 1999. At the outset, the record does not substantiate that defendant transmitted herpes to Stephanie. Stephanie did not even testify that the defendant infected her with herpes. Indeed, defendant's medical records show that he testified that he tested negative for herpes in June of 2000. Dr. McGrath began treating defendant for herpes on some date thereafter in the year 2000. Thus, Stephanie's claim that she was infected with herpes by defendant in 1999 is simply unsupported by the evidence and her own testimony. The government continually overlooks that 1 in 6 people have genital herpes. Defendant is not the source of every person on the planet with herpes. Stephanie's claim that defendant infected her with herpes is contradicted by known facts. That aside, the government fails to show that Stephanie's purported affliction with herpes between May 1999 and October 15, 1999, during the conduct alleged in Racketeering Act 2, as discussed supra, the government must show that Stephanie is a person directly and proximately harmed as a result of an offense for which restitution may be ordered. United States versus Goodrich, which was heard in 2021. Defendant was convicted for an act of sexual exploitation because he allegedly filmed a single sex act with Stephanie between May 1999 and October 15, 1999, when she was 17. Restitution may only be imposed for losses arising from the specific conduct alleged in Racketeering Act 2. Because Stephanie cannot show that she contracted herpes from defendant during the conduct alleged in this charge or at all, she is not entitled to restitution. Okay. Let's see. And then they talk about the Valtrex again and how it costs way more than the generic brand. And basically, if they're going to give her restitution, it needs to be for the generic brand. So then we go down to section 10. The district court lacked authority to order the BOP to turn over money seized from defendant's trust fund to the clerk of the court for future restitution payments. Final judgment was entered against the defendant on June 30th, 2022. As part of that judgment, the district court entered an assessment of $900, a $40,000 JVTA assessment, and a fine of $100,000. The district court deferred a restitution finding. Okay. It says on or around August 4th, 2022, the Bureau of Prisons seized roughly $27,000 from defendant's inmate trust account without a court order, without notice, without filing a lien on the property, without filing a notice of default, and without providing defendant with a receipt for the funds. In a pleading filed over a month later, the government admitted that it directed the BOP to seize defendant's trust fund account monies and sought an order for the district court directing the BOP to turn over the seized money to the clerk of the court for deposit in an interest-bearing account pending a determination as to restitution. The district court granted the order. The district court lacked authority to direct the BOP to turn over roughly $27,000 seized from defendant's trust account because defendant was not in default and was not provided with any default notice. There was simply no authority for the government to order the BOP to seize defendant's monies. And then she cites Title 18 United States Code Section 3613A, 3572I. Likewise, the district court lacked authority to direct the BOP to place the seized funds from the clerk of the court for use against a future potential restitution judgment. And it's worth noting here that Ann Dunley is the court that they are referring to. So we don't expect any better from her. So neither the government nor the district court cited any authority for the proposition that the government may restrain defendant's property preemptively for use against a future restitution award that has yet to be entered. Okay, so case law on this issue is slim, but two district court cases provide some insights. In United States versus Hickman, which was heard in the Western District of New York in 2018, the government moved the district court to authorize payment from the defendant's trust account in order to satisfy the criminal monetary obligation imposed by the judgment against the defendant. The district court denied the request because the government failed to present evidence of default in his payment obligation. See also United States versus Woodard, which was a case heard in the Western District of Michigan on June 24, 2016, denying the government's motion for an order authorizing the BOP to turn over defendant's trust account funds to pay a court-ordered fine absent any evidence that the fine is unpaid or in default. What occurred in the instant cases is even more problematic, where the government ordered the BOP to seize defendant's money without first seeking leave of court. The government acted prematurely and without legal authority when it ordered the BOP to seize defendant's money from his trust account, absent any showing that defendant defaulted or had shirked his payment obligations. The district court abused its discretion when it directed the BOP to turn over the funds to the clerk of the court for payment against a restitution award that had yet to be entered. Okay, let's see. Conclusion. Thank God. So we are at the end, y'all. We at the end. So it says, for the foregoing reasons, defendant's convictions must be reversed. Alternatively, defendant is entitled to a new trial. Separately, the restitution award must be vacated and defendant's trust fund monies should be promptly returned to his account. Jennifer Bonjean and Ashley Cohen, dated April 18, 2023. Certificate of compliance, blah blah blah, basically saying that they did this in the proper typeface, point size, and they used double spacing. The total number of words in the brief based upon Microsoft Word count exclusive of the cover, table of contents, table of authorities, and signature is 24,713. And I think that that is important to note because she had requested to the court that she be able to submit her motion of 19,000 words. So she went over that by what? 5,713 words. So hopefully they won't hold that against her. So guys, that's it for me. We made it through, okay? We made it through. Now what I need y'all to do for me, okay, if you made it to the end, some of y'all have been asking me to read those text messages. Now I want y'all to know that them text messages was 175 pages. So just like I did with this this thing here, this appeal, I will have to break it up into sections, okay? So if you guys want me to do those text messages, please let me know in the comments. Not the comments of the video, but down in the comments, right? So that I can come back later and see what you had to say. And maybe I'll see if I can put up a poll here in this actual video here and see what type of feedback y'all give me. But anyway, we are at 2 hours 5 minutes and 40 seconds. So that's it for me. This is the conclusion of the reading of the appeal, and we shall wait and see what the Second Circuit has to say and if the government responds. I was telling you guys about my kid's father when we petitioned the court for him to be released under the First Step Act Amendment of 18 under Donald Trump. The government didn't respond. So that's how he got out. Basically, the government didn't respond. The judge gave them like 5 months to respond. They just didn't respond, okay? And so she said, okay, well, as long as he got a place to stay, once I released him, he'll be on supervised release for 3 months, and then after that I think he's on like 5 years of probation, and then she let him out. Child said go on home. So that's kind of how the courts work. So we'll have to wait and see if the government responds, and if they respond, then of course I will bring that to you. And like I said in the video yesterday, I'm not even sure it's a requirement for the government to respond. I know in state appeals the government responds, but I'm not sure if it's the same way in federal court. So anyway, go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye bye.